Oi, sejam muito bem-vindos de volta ao canal Hallyu no Brasil. No vídeo de hoje nós vamos ter uma entrevista com a professora Erin Chang, que é uma professora de ciência política na Johns Hopkins University, nos Estados Unidos. Ela tem toda uma pesquisa sobre os vistos na Coreia do Sul e como eles colocam os imigrantes em certas categorias. E é sobre isso que nós vamos falar hoje. Então agora fiquem aí com a entrevista. Thank you very much, Professor Erin, for being here today. Can we start with, can you please introduce yourself and tell us a little more about your research?
Sure. So my name is Erin Chang. I teach in the Department of Political Science at the Johns Hopkins University in Baltimore, Maryland. And I'm also a co-PI for a project on critical responses to anti-Asian violence that we just initiated this past year. And I previously served as the director of the East Asian Studies program and also as the co-director of the Racism, Immigration, and Citizenship program. My research is largely on comparative migration and citizenship politics, as well as comparative racial politics. And I also study civil society and the political economy of development. And my geographic focus is on East Asia, so specifically Japan and South Korea. I wrote my first book on immigration and citizenship in Japan, which focused specifically on contemporary immigration and citizenship politics, but I was looking at the ways in which colonial era Korean migrants and their descendants kind of created the blueprint for contemporary immigration politics in Japan. And my second book, which was published in 2020, is entitled Immigrant Incorporation in East Asian Democracies. And this book compares immigration politics in Japan, South Korea, and Taiwan. And I'm basically explaining why three countries with overlapping immigration and citizenship policies end up having highly divergent immigrant incorporation outcomes. And I'm largely pointing to the role that what I call civic legacies play in shaping these outcomes. And that's basically the ideas, institutions, and networks that previous civil society actors have used to basically make claims for historically marginalized communities and how that's then shaped immigration politics. So I'm happy to join you today, and I know that we'll be talking specifically about South Korea.
Yes, you have very interesting research topics, and the one that talks about the visas in South Korea specifically caught up my attention. And if we could start the conversation today talking about the visa types that South Korea has and how they categorize the immigrants.
Right. So I wrote an article that's entitled, Creating Hierarchies of Non-Citizens, Race, Gender, and Visa Categories in South Korea in the Journal of Ethnic and Migration Studies. And this came out of my broader book project where I had been doing 7 years of field research in Japan, South Korea, and Taiwan. And I did extensive research on using government documents and other archival research, as well as personal interviews of government officials and migrants themselves, as well as advocacy organizations, and then focus groups with over 20 immigrant communities. And I should note that in one of my focus groups in Japan was actually with the Brazilian community in Japan. so I gained a lot of insight about the Brazilian community, especially ethnic Japanese, known as Nikkei from Brazil, who are residing in Japan. But obviously, I didn't do a focus group on the Brazilian community in South Korea because it's very, very small. But in any case, I was really focusing on the question of visas and how In many ways, they map onto kind of racial and gendered meanings to kind of institutionalize these non-citizen hierarchies. And this has a lot to do with basically trying to understand how, basically countries that have largely closed or kind of only slightly opened immigration policies are able to, one, kind of shape patterns of immigrant incorporation, but also are able to maintain particular hierarchies, among migrant communities. And in South Korea's case, and it's also true for Japan and Taiwan, the kind of slightly opening of borders was very much accompanied by the proliferation of visa categories for a diverse range of migrants. And while this doesn't seem out of the ordinary, because obviously every country has multiple visa categories, I found that in my research that these visa categories determine not only the length of residence that a migrant was eligible for, and employment opportunities and restrictions and so forth, but they tended to really be specific to the category of migrant that was really very much tied to their gender and national origins, and that really went beyond the demands of the labor market. So they weren't purely just based on the economy. And so what I'm basically arguing in the article is that basically the visa categories themselves are informed by racial, gendered, and class-based meanings, right? And so these might be stereotypes about people from particular countries, or about female spouses of Korean nationals. And so they kind of inform the visa categories to begin with. For example, the creation of this so-called marriage migrant visa is based on the assumption that the only people who will receive them are women, right? So it's a very gender type of visa. And then I also demonstrate how these visas themselves then institutionalize these forms of gendered and class-based and racial meanings, right? Because in many ways, they by linking a particular visa with a particular category of people, as well as particular state institutionalized rights, right? It actually, in many ways, creates a kind of durable type of inequality for particular non-citizen groups. And then I examine how together, how both the extension of these meanings and then the institutionalization of those meanings through the visa categories shape actual patterns of incorporation. So that's basically what I'm doing. And the article itself is comparing visas for co-ethnic migrants, namely Koreans, ethnic Koreans, mostly from China and the former Soviet Union, but also from the United States and Japan. And then also the visa categories for female spouses of Native Korean men.
And the ones that create this hierarchy between immigrants are the ones specifically for work and spouses, or there are others that help to create this situation?
They definitely can be divided into three. So the first would obviously be specifically working visas, right? Because, and this is definitely due to the fact that South Korea still has very exclusionary policies toward unskilled labor. And so the borders remain relatively closed unless you are able to enter through very specific visas. So it'd be the E9 non-professional employment visa is for Korea's guest worker program, the employment permit system. And then there is a specific visa just for ethnic Koreans from China and the former Soviet Union, which is the H2 working visit visa. And that one is very similar to the first one, except that there are no restrictions for employment. You can actually, those who have the H2 working visit visa can change workplaces, and they're not tied to a particular industry. And then there is the other visa, that's the other category of visa, are specifically for the spouses of Korean nationals. And the one that I focus on is the F6 or marriage migrant visa. And that covers a number of different subcategories, but it is specifically for a spouse of a Korean national. And that one is a very generous visa, so the two working visas I just mentioned have very specific, residential kind of restrictions. So they can be renewed for 2 years. So the first instance of the visa, you would stay for 3 years, but it can be renewed for another 2 years. But the maximum stay is 4 years and 10 months, which is 2 months short of the permanent residency and naturalization, continuous residency requirements. So that basically makes it very difficult for those who are entering on a working visa to permanently settle in South Korea. Whereas the marriage migrant visa is a 3-year visa, but it allows for multiple renewals. And also marriage migrants have access to simplified naturalization. So oftentimes they don't have to wait the full 5 years. They can actually take a citizenship exam or go through a particular set of training in order to be eligible for a simplified naturalization. And then the final kind of big category of visa is the co-ethnic visas, and the one that I focus on is the F4 overseas Korean visa. And that one was really also contentious too, because it should, and ideally, it should be for all co-ethnic migrants, right? Because that's the whole idea behind having an overseas Korean visa. But until 2003, basically Koreans who had migrated from the Korean Peninsula before 1948, when the Republic of Korea was founded, were not eligible for that particular visa. And the vast majority of those Koreans were Koreans from China and Koreans from the former Soviet Union. And Koreans from China, make up the vast majority of not only co-ethnic migrants in Korea, but also all immigrants in Korea by far, right? And so it was very noticeable and perceptible that the largest co-ethnic migrant population was not eligible for this very, very generous visa, which basically provided kind of quasi dual citizenship rights, like property rights and investment rights and health insurance, and also made those visa holders eligible for dual citizenship as well. So it was, even with this kind of co-ethnic visa, there was this kind of creation of categories, right, and hierarchies even among ethnic Koreans, ethnic Korean migrants to Korea.
So taking a little bit further with the working visas, I've talked with 2 Brazilian women that live in South Korea, and they both worked there, and both of them didn't receive any salary for their work. One was with unskilled jobs, this one's with farms, I guess, and the other one was with a entertainment agency, and both of them didn't receive any payment for it. Do you think that this is related to this visa problematic, or it's more of a structural thing?
So it depends on the timing. So basically, I would say that any visa that was that people received prior to 2004 would have likely been under the guise of an industrial a trainee program, which was established in South Korea in 1993. And this was basically an informal guest worker program, which was really, a way for for South Korean companies to import unskilled workers without really acknowledging, that they were workers formally. And this program really left so-called trainees really vulnerable to exploitation, since they were not recognized as workers and thus not protected by labor laws. And so the problem of unpaid wages, in other cases, passports being seized, by the employers and the workers kind of held hostage as a result of that, and other forms of exploitation, which included contract violations and also industrial accidents that were uncompensated and so forth, were really endemic problems to this the industrial trainee program that had existed in Korea from 1993. So it was really with the introduction of the formal guest worker program, the employment permit system in 2004, that migrant workers that were actually eligible for labor rights, right, and were formally recognized as workers. And the employment permit system, in theory, right, it guarantees labor rights and is very much kind of emphasizes the human rights of migrant workers, and a number of organizations that are associated with the EPS, including unions, EPS type of unions themselves that are organized by foreign workers, do try to convey what rights migrant workers have. Nevertheless, right, because in many cases, there are a number of illegal practices that continue to, really dominate some of the industries, which are largely in, construction and manufacturing, right? But you do still see these kinds of problems and contract violations, unpaid wages. So these are the issues that migrant advocacy organizations in particular are really working on. So I would say that those two issues of unpaid wages and contract violations are the two most commonly cited violations that I've heard of.
Yes, I got very curious about these visa regulations because I read that the employee is legally attached to the employer. So they can only change jobs if the employer allows them to go, and so on. So they can't get another job if they don't have the visa, but then they can't get the visa if they don't have the job. So I just got very curious about these working jobs dynamic to get the visa.
Right. So so even though, like I said, even though the employment permit system on paper, claims to guarantee the human rights of migrant workers, and also very much that these migrant workers are protected by labor laws, the central problem is that the E9 visa, the visa specifically associated with the employment permit system, is linked specifically to the employer, right, to the particular company, and so basically, if you have an H2 work, if you have an E9 non-professional employment visa, you are eligible in theory to have 3 workplace changes, right, in the first 3 years, but they have to be approved by the employer, right? And so you're basically at the mercy of your employer to make these workplace changes. And the other restriction is that the workers are restricted to employment in a single industry, right? So you can't change from construction to manufacturing, or to agriculture or fishery. You have to stay in the very same industry. So it does make it very difficult for workers to, one, seek jobs that are, have better conditions or that are higher paying, right? And it makes it very difficult too for them to complain about workplace conditions because, their very employment and ability to change workplaces is very much dependent on their employers. And so that in itself really does create this kind of exploitative, condition where workers are very vulnerable, right, to kind of the arbitrary demands of their employers, who may not always, for whom they're, workers staying in their company is probably, the most ideal condition, right? Especially at a particular wage level.
Yes, in your researches, by any means, did you see any possibilities for to make it better, these situations, these hierarchies, these type of issues that happens with the visa? There's any possibilities for changes, or for the time being, this is it?
Well, I think that basically workers and other foreign residents in South Korea have used two primary methods. One is protest and also, engagement with advocacy organizations, and involvement in labor unions. So what you might expect, right? And so I think that the migrant workers labor unions have been very effective, right, in identifying these recurring patterns of exploitation and discrimination. And also advocacy organizations themselves often serve as negotiators between the employers and the employees. And this is especially effective for more newly arrived workers who may not have the fluency in Korean, to be able to negotiate with their employers. So that has been an effective way for workers and advocates to first draw attention to the problems, and to also negotiate individual kind of workplace problems, and also to lobby for more kind of strict regulation of these workplaces, and lobby for more state institutionalized rights, especially labor rights. So that's kind of one avenue. The other avenue has been through the courts, right? So one of the examples that I discuss in my article is the overseas Korean visa that I mentioned. So as I mentioned, until 2003, ethnic Koreans from China and the former Soviet Union were excluded from the overseas Korean visa, which was based on the definition that overseas Korean was equated with Koreans with foreign citizenship, and Koreans who had previously held South Korean nationality and their descendants. But the vast majority of overseas Koreans, right? In other words, ethnic Koreans who've migrated from the Korean Peninsula are colonial era migrants and their descendants. So, like I said, they didn't qualify according to that definition. And so it was actually through a lawsuit that was filed by 3 Korean Chinese migrants and their supporters that this law was changed. So this lawsuit was filed, and the Korean Constitutional Court ruled in 2001 that this provision that had excluded the the colonial era migrants, so pre-1948 migrants and their descendants violated the principle of equality in the Constitution. And so in response to this ruling and pressure from civil society groups within South Korea, the National Assembly passed a 2004 amendment that made post-1948 immigrants and their descendants eligible for this visa. Not everyone, so the story is a little bit still complicated, but it basically replaced the prior South Korean nationality requirement with evidence of having what's called a household registration or hojok in Korea. And this allowed for, a significant number of Korean Chinese and Koreans from the former Soviet Union to apply for the overseas visa. So basically, this meant that those holding the overseas Korean visa went from there were 0 Korean Chinese who had that visa up until 2003. And then, by about 8 years later, it was about 70% that were Korean Chinese that were holding this visa. So it was a really effective campaign, basically, to hold, Korean lawmakers and the Korean public kind of accountable to the principle of equality under the Korean Constitution.
And on the other hand, you mentioned the spouses visa and how they're focused on women. Could you talk about more about that? How so it is more towards women, and if there's different rules for women and men that apply for the spouse visa?
Yeah, so that's a really interesting question, because obviously a spousal visa should not be based on gender, right? There are spousal visas, that are issued throughout the world, and they're never just based on a particular gender. But in this case, this has a lot to do with kind of a proactive effort made by local governments, as well as even to some degree national government officials, to really recruit spouses for what was then and still kind of now a major problem in South Korea, which is the demographic crisis or the upcoming demographic crisis. And so you already may be familiar with the current situation, which is Korea, as well as Japan and Taiwan and Singapore and Macau. So has been basically one of the fastest aging populations, and also has had one of the lowest birth rates. In fact, 2 years ago, it had the lowest birth rate, in the world, and also has one of the fastest shrinking workforces in the world as well. So it's this very big demographic problem, and this was especially pronounced in the rural areas, right? So in the cities, obviously birth rates were still quite low, but the aging population and the shrinking workforce were not quite as obvious. But in the rural areas that were already depopulated because so many people had moved to the cities, to the urban areas, this was becoming a problem both for largely unmarried male farmers and their parents, right? Their aging parents who, based on the kind of traditional patriarchal structure, were supposed to depend on their sons and their daughters-in-law to take care of them in old age, right? So as the population of unmarried male farmers was growing, this was causing major problems for this rapidly aging population, right? Who did not have a support structure, right? Because there were also, the welfare, social welfare structure in South Korea, especially in the rural areas, are still fairly undeveloped as well. And so some entrepreneurial associations, local associations, and local government officials actually started creating campaigns to recruit female spouses, right, for their unmarried bachelors. And initially this campaign was kind of a more domestic one, where they were trying to target women within South Korea. And then they started to try to attract more women from China. And this was especially after South Korea and China established diplomatic and trade relations in 1992. And so this basically opened the door to these kind of arranged marriage meetings between Korean men and ethnic Korean women from China that were brokered by these local government officials and agricultural associations in rural areas. And this exploded after the South Korean government deregulated the marriage industry in 1999. After that, hundreds of private brokers established international marriage agencies that really widened the pool of marriage migrants to other parts of the world, especially Southeast Asia and Russia, such that so this is like in about a decade between the time that the government deregulated the marriage industry and 2009, the number of female migrants who had entered Korea as spouses of Korean nationals reached over 125,000. So this was just a very short span of time, and this was when international marriages then made up 10% of all marriages in Korea. So in this very short period of time. And so it wasn't so much a coincidence that it was, just happened to be women who were entering on this. It was actually very much a proactive effort by local government officials, as well as these international marriage agencies and brokers that really kind of sought to alleviate what was being called the so-called bride famine, right, in South Korea. So obviously, the marriage migrant visa is not limited to women. It's just that the overwhelming number of migrants who are coming to Korea, who are using that visa are in fact women. But I think that one interesting development that's not really discussed as much is that among North Korean migrants who've been coming to South Korea in the last decade or two, quite a few of them actually have come in with their spouses who are in fact male. So like the majority of North Korean migrants to South Korea in the last 2 decades have been women, right? And of those who are married, actually, a good proportion of them are married to Chinese men who then, become marriage migrants as well. But so they're kind of the exception to the rule. And so when we do talk about marriage migrants in South Korea, we're usually talking about women.
That's very interesting. So in general lines, what do you think a person should be aware of when they are thinking about immigrate to South Korea and then facing these visas? Is there something that they should be aware of before they jump into this?
Well, I think the main takeaway should be that permanent residency is oftentimes very difficult to attain if you're entering South Korea through one of these visas that are based on the employment permit system, or that are otherwise, catering to unskilled workers, right? Because the visas themselves basically make it very difficult for those who have that visa to become eligible for permanent residency or naturalization. It's almost built into the visas themselves, right? On the other hand, the overseas Korean visa and the marriage migrant visa are largely acknowledged as being kind of the easiest route to permanent settlement and citizenship acquisition in South Korea. So I think that, you know, those who are interested in going to South Korea and settling permanently should understand that there are these two different routes, right? One which is very much kind of provides a pathway to, you know, Korean citizenship, or at least to permanent settlement, which is reserved for the co-ethnic Koreans who are eligible for the overseas Korean visa and marriage migrants. And then the other route, which is largely for unskilled workers who are able to stay in Korea for, you know, a little bit less than 5 years total, but basically, you know, would find it very difficult to settle permanently in Korea. So I think that needs to be acknowledged. So although South Korea has made a number of very progressive reforms in the last two decades, much more so than Japan, right? And although, you know, the issue of human rights protections of migrants and such areas as local voting rights for permanent foreign residents, and even just the kind of the local campaigns that are trying to, embrace the idea that South Korea is becoming a multicultural society. So even though you've seen all these really kind of progressive developments in the last 2 decades, there still is a great deal of asymmetry, right, between migrants themselves. And, this is not just about discrimination or prejudice within Korean society. It's very much built into the visa system of South Korea.
I guess that's it for today. Is there anything else that you think that should be said about this matter?
Well, I think that I do think that there are opportunities for continued change because, like I said, South Korea still very much does, try to distinguish itself in Asia as being kind of very progressive in terms of immigration reform and immigration rights, and the central government has very much made multiculturalism really kind of one of the highlights of various administrations, both at the national level, but also at the local level. So I do think that there is room for claims making based on this, based on kind of democratic principles on the one hand, but also on the claims that South Korea is becoming a multicultural society as well. So I think there is a great deal of room for migrants to demand rights and to demand reforms. And there is no shortage of partners and allies who also are fighting for migrant rights in South Korea.
That's great. Thank you very much, Professor Erin Chang, for sharing your knowledge with us today. And yes, thank you very much for your time and for accepting this invitation.
It was my pleasure. Thank you.
E é isso para o vídeo de hoje. Esse vídeo faz parte do projeto Hallyu no Brasil, uma narrativa transmediática experimental a respeito da onda coreana no nosso país. Se você quiser saber mais sobre o caso da onda coreana no nosso país, você pode acessar o nosso Instagram, que é @hallyu.brasil. E você também pode escutar a história que eu contei, que eu perguntei para a professora sobre as 2 brasileiras que trabalharam sem receber salário. Você pode escutar toda a história do nosso podcast, que é a Hallyu no Brasil. Tchau!